Before talking about land and property registration, let me talk a bit about meaning of land and property. In its simplest definition, land is a piece of surface of earth. Property is a slightly wider concept. It includes things or objects that have some value for the human beings, such as money, gold, land, houses, cars, etc. In connection with land, a term immovable property is used under the Indian law. Immovable property includes land and things permanently attached to land. In this lecture, we will be discussing registration of immovable property. The term land and property used in this lecture would actually mean immovable property. After knowing what is property, let us understand what is registration. As the word itself suggests, registration is the process of recording details of something in a register. So, property registration is a legal process of recording property details and the rights of people attached to it in a public register maintained by a government authority. From people's point of view, registration provides security of tenure, facilitates property transactions, and reduces property disputes. For the government, there are multiple uses of property registration, such as efficient management of land resources, urban planning, agricultural development, and identification of weaker sections for government schemes like small and marginal farmers, landless laborers, and houseless people. In modern times, most countries have a system of property registration. However, the form and procedure of property registration vary from country to country because of differences in their socio-economic conditions. Property registration systems are classified into two broad categories: deed registration system and title registration system. The title registration system is also referred to as the system of conclusive title, system of guaranteed title, or torrent system. Let us understand the basic difference between the deed registration system and the title registration system. In the deed registration system, a written conveyance deed signed by the parties to a transaction such as sale, lease, gift, or mortgage is presented to the registrar for registration. The registrar only examines the completion of formal requirements such as correctness of format of deed, identification of parties, and their consent. He does not go into the legal validity of the title of the transferor and his competence to make the transaction. It is the responsibility of the parties to examine the legal validity of the transaction. Therefore, in a deed registration system, registration is only evidence of property transaction and not the conclusive proof of the transfer of title. In the title registration system, when an application for registration of property transaction is submitted to the registrar, he examines the legal validity of the transaction in detail. He registers the transaction only if he is satisfied that transferor has a clear title on the property and there is no legal hindrance in passing the title to the transferee. Once an entry in the name of the transferee is made in the register, it is considered conclusive proof of his title over the property. An entry in the register is considered sacrosanct even if it was made due to some mistake on the part of the registrar or the parties to the transaction. Therefore, a genuine right holder who loses his property due to an incorrect entry in the register can't get his property back. However, he is compensated by the government for his loss by paying him money equal to the value of the property. I would try to elaborate on this concept through an example. Suppose a person B gets registered the property of A in his name by misrepresentation of facts. Then this property is sold by B to C without the consent of A, who was the actual owner of the property, and this transaction is also registered. Let us see what remedy is available for this situation in both the registration systems. In a deed registration system, A can get his property back from C by going to a civil court. He would argue that the sale of the property by B to C was illegal, as B had no right to sell his property. In this case, C, despite being a bona fide purchaser, will lose his property. However, A can't get back his property in a title registration system. This is so because title registration system protects a registered owner and a bona fide purchaser. A can claim monetary compensation from the government, but he can't get his property back. It is difficult to say which system is better. Both systems are widely followed in the world, and there are examples of successful land administration under both the systems. Now let us talk about the property registration system in India. India follows deed registration system, which was introduced in the year 1793 by the British. Under the Registration Act 1908, it is compulsory to register property transactions such as sales, gifts, long-term leases, mortgages, etc. Certain transactions such as transfers through inheritance, family settlements, leases up to 1 year, equitable mortgages, mortgages for agricultural loans, court decrees, and grants of land by the government are exempted from registration. I will now briefly explain the process of property registration in India. Here I am taking an example of a sales transaction. A similar process will apply to other transactions also, such as mortgage, long-term lease, gift, etc. First, the seller and buyer negotiate the terms and conditions of a transaction. Sometimes an agreement to sell is also executed at this stage, but it is not compulsory. As mentioned earlier, in a deed registration system, the registrar does not investigate the validity of the title of the seller. Therefore, the legal validity of the seller's ownership and his right to sell the property has to be ascertained by the buyer himself. This is done by him by searching the old records of the deed registry, municipal tax records, records of rights, and other such records. If upon investigation, title of the seller is found valid, both parties sign a sale deed and present it to the registrar for registration within a period of 4 months. The registrar examines the deed to ensure that it is presented within the prescribed time limit and contains all the details as per the Registration Act. Then he verifies the identity of the parties and also inquires whether the deed has been signed by them. Once satisfied, he records a registration certificate on the deed and retains a copy in his office for future. As mentioned earlier, the objectives of the property registration are to provide secured ownership, facilitate future transactions, and reduce property disputes. I will now talk about legal provisions to achieve these objectives. The record of registration is open to the public. Anyone can see this record and obtain copies of record following a prescribed procedure. As the registration record is open to the public, registration of a deed has a legal effect of giving notice to everyone interested in that property. A transaction that is required to be registered by law is not valid unless it is registered. An unregistered deed for such a transaction is not accepted as evidence in the court of law. However, registration of a deed has certain limitations. Registration is evidence of transaction, but it does not confirm the transfer of title in favor of the transferee. The transfer of title depends on many other factors that are not examined by the registrar at the time of the registration. If the transferor does not have the right to transfer, the transferee will also not get the title over the property. Any defect in the title of the transferor gets automatically transferred to the transferee. For example, A sells a land to C through a registered sale deed, hiding the fact that half of the land belonged to his brother B. In this case, the purchaser C will not become the owner of the full land just by registration of the sale deed. Regardless of what is written in the sale deed, C will become owner of only half of the land that was under the ownership of the A. Another limitation is that in most cases, a cadastral map of property is not attached to the deed. Therefore, the boundaries of the property cannot be demarcated using the registered deed. As mentioned before, many transactions such as inheritance, family settlement, equitable mortgages, court decrees, government grants, etc. do not require registration. Such transactions do not appear in the record of the registrar. Thus, the record of registrar does not give a complete picture of property ownerships. These limitations of Indian registration system can be overcome by making certain changes to the law. Unfortunately, the registration law, which was enacted about 120 years back by the British, has not changed much. There is an urgent need to upgrade this law to meet the challenges of the modern times. I would mention here a few changes in the law which can greatly strengthen our registration system. First of all the exemptions from the registration should be removed. All transactions affecting property rights must be made through a registered deed. This will ensure that registry records have a complete picture of the rights in the property. Next, registration must be linked to record of rights maintained by the revenue departments of the states. It should be made compulsory to attach copies of cadastral maps and ownership register along with the conveyance deed. This will help avoid boundary disputes in future. Further, the registrar should be empowered to verify prima facie proof of ownership before registering a conveyance deed. This will prevent illegal transactions to a large extent. Many disputes are caused due to transaction of properties under litigation. A buyer has no way to know about the pending litigation at the time of registration of a sale deed. If registration of pending litigation is also provided in the law, it will prevent future disputes. Lastly, registration process should be fully computerized. Computerization will make registration process quick, easy, and transparent. It will be much easier for a prospective buyer to verify the title of the seller by making a search on the records of the registrar. Before concluding, I would summarize main points of my lecture. In the beginning, I talked about the definition of land and property. Then I told you about the basic concepts of registration and purpose of registration. Further, the main features of deed registration system and title registration system were discussed. After that, I talked about Indian deed registration system along with law and procedures of this system and responsibilities of various stakeholders. In the end, I talked about limitations of Indian registration system and gave a few suggestions to improve the present system. I hope that you find this lecture useful. Thanks.